So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we go to the Fourth Circuit Court of Appeals, where the judge said that with respect to the Americans with Disabilities Act, just merely labeling a list of suggestions as an accommodation request is not enough to inform the employer that the employee is requesting workplace changes to address his disabilities rather than other unrelated issues. And what this happened was in Kelly versus the town of Abingdon, which you can see here, the town manager, which was Gregory Kelly, he had quite a few different medical issues, including high blood pressure, depression, and anxiety, which he said that it actually came from the behavior of the town council and the mayor, specifically surrounding their behavior in the workplace, the political infighting that was going on, and all of the things surrounding it. And so before filing the charges with the EEOC, the town manager, the Greg Kelly's attorneys, sent a letter to the authorities of the town and were looking for changes to the office environment. And they titled the letter accommodation request and specifically called out the ADA. But the goal for the letter was to create a, quote, foster a well-running office. And so it appears to sort of stray away from the overall concern with respect to the ADA and so forth. And there were quite a few different requests made, but none of them were, again, specific to the ADA. They were talking about equal treatment, building teamwork, development of policies, ending the threats of termination, creating a code of ethics. And to be mindful here, the town of Abingdon is pretty small. I think it's about 30,000 on the border of Virginia and Tennessee. But they were wanting, a better environment in the workplace, and that's what he called out. He didn't call out his own medical condition or how these requests would somehow create a better environment for his medical conditions. It was simply a letter. Eventually, the town manager resigned and sued under ADA for interference with his rights to reasonable accommodation as well as retaliation. Ultimately, the Fourth Circuit Court of Appeals rejected these claims and said that, while employers have to provide disabled employees with reasonable accommodations to allow them to do their job, their essential job functions, they only need to accommodate what's known, and they also need to make a clearer request. It's really easy. The Fourth Circuit Court notes that, quote, it is not difficult to request an accommodation. To trigger an employer's duty to accommodate, a disabled employee need only communicate disability and desire for an accommodation. And really, it seems like the corporate lawyers who were supporting the town manager Kelly, did a really poor job of articulating the fact that these specific accommodation requests were tied to his request for accommodation, and that they were somehow, again, tied to his anxiety, depression, and high blood pressure. So there aren't any magical words required for the request, but it is necessary to make it clear that the employee wants assistance. Now, the Fourth Circuit said there must be a logical bridge connected the employee's disability to the workplace changes he requests. And that's what failed here, right? He didn't connect the two. He simply threw out things that could make any workplace better, regardless of his situation, right? Any workplace would be better with ending the threats of termination. And he didn't tie the actual request to his accommodation. And it's important to understand that by requiring employees to articulate at least enough information for the employer to understand that a request for assistance is connected to the disability will trigger ADA. There's no magic words, there's no specific things that need to be said, but it has to be more specific than a general list of things sent to the town that are also just general best business practices in the workplace. And I think that this serves as an interesting and helpful argument so that people will understand in the future what they need to do when they're requesting a reasonable accommodation. Reasonable accommodations aren't simply, hinting or mentioning off the cuff, but rather it's a very specific and definite articulation of what needs to be done. And that just serves both the employee and the employer. It sets the expectations, it creates things to be quite clear, and that's what we should all strive for in our daily life. Let me know what you think in the comments down below. Have you ever tried to do a reasonable accommodation request? How'd it go? If you'd like to check out this case and read more about it, you can definitely check out the link and let me know what you think. Leave a comment, like, share, subscribe, and we'll see you on the next video. Bye, guys.